because the Commission had engaged with the Hawks to say, we're aware of these complaints, the first of which laid in 2016, the second of which laid in 2017, the third of which laid in 2018, and we've seen no movement in relation to those cases. They gave us a report of what steps had been taken in relation to the engagements, and it concluded on the basis that the investigation needs speedy conclusion. Those were the notes of the report from Lieutenant General Labia.
What did the conclusion say?
That the investigation needs speedy conclusion. Right.
Okay.
So, Chair, we interrogated the report because we wanted to understand precisely what has happened since 2016 to 2019.
Yes, and why there hadn't been a speedy conclusion all
until
along.
That point, indeed.
Yes.
Chair, that precipitated correspondence, further correspondence and seekings of clarity. The report itself indicated certain bank statements had taken very long to be produced, had been requested again, that there'd been an attempt to consolidate the cases. Chair, the upshot that I report to you today is that none of the clarity that we've been, attempted to be given has actually advanced the matter. It raises more questions, in fact, than it answers. And I raise that with you today, Chair, because it is our proposal that we continue to engage, to try to understand why 3 years since the first complaint.
Yes.
These matters have not progressed.
Yes.
And Chair, it is with a view in due course, once we get to the bottom of this, to make recommendations in our submissions to you about what you may consider in a report in due course. Chair, our thinking there is, if this can be explained by matters of incapacity, well, that's one thing, and it may well influence the type of submissions we would make to you in relation to recommendations following from the Commission. There is also concern, though, that there may have been delays in this prosecution of the matter for other reasons.
Yes.
And we are in the process of engaging those matters with the Hawks.
Yes.
So my request to you today is that we continue to probe the matter, that we update you as and when we believe we have a full picture. I would not be in a position today to give you a full picture because there's much that still needs to be interrogated, but we would do so in advance of making any submissions to you, Chair, about what our proposed recommendations may be in relation to these matters.
I'm disinclined to deal with it simply on the basis that whatever we may need to do may only be done at the time of preparing the report.
Indeed, Chair.
Certainly, it will be important at that stage to know as much as possible about these types of delays, what causes them, and so on. But I think that we should seek to assist, if we can, in one, understanding why either nothing or very little has happened, and two, seeking to have the action that is required to be taken to be taken.
Indeed.
What we may have to consider, I think the first thing is to try and get as much information as possible as to what has been done, and then one option might be to then bring this to the attention of the leadership of whatever and law enforcement agencies are involved, whether it's the Hawks or the SAPS, and maybe ask them to see to it that something is being done, and maybe to consider holding certain people accountable. But it may well be that we should consider whether senior people shouldn't come here and explain what has happened. But we don't need to, if we can avoid, let the time that we have, which is limited, for the hearing of witnesses who would be telling us about various matters, let some of it be taken by
Indeed.
those matters. But at the same time, it may well be that it might send the right message if people were to be called and to come and explain publicly what is happening. Because if it's a question of incapacity, not having resources, one would expect them to come to be open with us and say, look, the reason why there's been no action is because we just have too few police officers or something like that.
Indeed.
And then give a full breakdown of what is there, what's available, and so on. But also one would want in that situation to understand what efforts have been made to bring that situation to the attention of senior authorities, to
Indeed.
say, look, we can't carry out our functions in this area, in this community, because we don't have enough resources, and this is the situation, or whether people just haven't done anything.
Indeed.
So maybe you could think along those lines, and obviously, whatever we do, we've got to look at what power we have,
Indeed.
because we don't want to be accused of doing anything that doesn't fall within our powers.
Indeed.
Yeah.
Thank you, Chair. That was just to conclude that aspect of the Northwest Ground handling transaction for present purposes. If I may then move to today and one or two procedural aspects. Chair, there has been a request. Mr. Mainganya, who's going to be sworn in shortly, is the Chief Risk Officer of the Industrial Development Corporation. Some of the documents that the IDC has provided to the Commission in their endeavours to assist with the investigation are commercially sensitive. There are 2 pages of a particular annexure that are commercially sensitive, and which there's been a request that we ensure are redacted from the public record when the bundles of today go onto the website. Chair, the legal team has considered the 2 documents, or the 2 pages of a document that appears in 3 places in the bundles after receiving the letter, and we have no difficulty with the suggestion that they be redacted. As a matter of fact, I don't even intend to take Mr. Mainganya to those documents today. And so with your leave, our proposal would be that that arrangement be made. It's set out in a letter which those documents will be. And Chair, I can just hand that up to you if I may.
Yes.
Chair, you'll see that it is a letter addressed by Cliff Decker-Hoffmeyer, who are the attorneys acting for Mr. Mainganya today. And the relevant documents in respect of which redaction is sought are set out from paragraph 4.1 on that page over to 4.3. Chair, my suggestion is this morning I was able to identify those documents with the legal representatives as they appear on the paginated pages in the bundles. And so my proposal is that if you're inclined to give the ruling, you do so with reference to the documents referred to in the letter, and then we will simply ensure that the correct paginated pages of the record are redacted.
Well, I would like to have sight of the actual document.
Certainly.
As well.
Chair, let me take you to that then.
Yes, but in the meantime, I'll just read this
Certainly.
letter. Okay, no, maybe even without looking at it, I've just finished reading this letter. Maybe what we can do is, maybe I can make the order with a rider that the order could be revisited should it become necessary later on, just in case.
Indeed.
Later on it might appear that there is something, particularly when I haven't looked at a lot of things. Yeah. So in that way, then one can always relook at it and either withdraw the order or keep it as it is.
Indeed, Chair.
Yeah. So is this identification of the relevant documents fine?
Yes, it is.
Okay. The information contained in the documents identified in paragraphs 4.1, 4.2, and 4.3 of the letter dated 28 August 2019 from Cliff Decker, Hofmeyer, addressed to the Secretariat of the Commission, will be included in the Commission's record only in a redacted form. Is that adequate?
Indeed, Chair.
Is that adequate?
Indeed.
Okay. All right, thank you. I think I must then say we'll make that one, and two will be the order in one above may be reconsidered at a later stage should circumstances dictate its reconsideration. Yeah.
Thank you, Chair. We're indebted. Chair, the final procedural aspect is just to update you insofar as Rule 3.3 notices in respect of Mr. Mainganya's evidence is concerned. Chair, as you'll see when we commence with Mr. Mainganya's evidence, it comes in two parts. There was an initial affidavit in respect of which a Rule 3.3 notice was issued to an implicated person. Pursuant to that notice being issued, we received an application for cross-examination from the implicated person, but that was subsequently withdrawn. There was then a further affidavit that was received from Mr. Mainganya on Wednesday of last week. And it was a supplementary affidavit. It's been placed in the folder, in the bundle that we will come to. In respect of that affidavit, there were three further Rule 3.3 notices that needed to be issued. They were issued on the Friday of last week, first thing in the morning. That means implicated persons obtained a week's notice of today's evidence. There has been only one response to that, and that was a response received yesterday from Mr. Komane's attorneys. Chair, that correspondence indicates, and if I may just beg leave to hand it up to you, Chair, before I go to it.
Yes.
Chair, the way it has been put together is the covering email that you see there is actually the email that the Commission sent in response to the letter that was received from Mr. Komane's attorneys. Second in the documents that have been handed to you is Mr. Komane's lawyer's letter. The essence of it, Chair, as I understand it, is that Mr. Komane places on record at paragraph 1 of the letter, which you'll find on the second page of it, that he denies any involvement in the alleged payments that are described, and we'll come to that in Mr. Mainganya's evidence. He goes on to raise concern that the allegation is based purely on hearsay evidence, with no corroborating statements, affidavits, or documents supporting the allegation, and furthermore lacks merit and is conceived to be unsubstantiated. And the concern is that it makes it impossible for their client to respond to it. At paragraph 3, concerns are raised about the public interest in the Commission and the prejudice to Mr. Komane, both in private and his public capacity, should the allegations be made public, as alternatively his client be associated with the allegations. And then at 4, they raise the concern that he hasn't been granted adequate time to respond to the notice and has not received all the necessary information to properly respond. And if you go to the last paragraph on that page, it concludes on the basis of a request that Mr. Komane be furnished with the founding affidavit of Mr. Mainganya, or any corroborating evidence that might exist in order for him to assess the merits and obtain the necessary further legal advice and assistance he's entitled to. Chair, the letter on its face did not make any claim in relation to the proceeding of Mr. Mainganya's evidence, but out of caution, yesterday evening, a letter was sent, that's the first letter in the pack, to the representatives, and it was made clear to Mr. Komane's representatives that it was the intention of the legal team to proceed with Mr. Mainganya's testimony. You'll see that at paragraph 3 of the email. It further went on to indicate that if Mr. Komane intended to object to the Commission proceeding to hear the evidence of Mr. Mainganya, that he was invited to send a legal representative to the Commission to make such representations. And it continued in conclusion to say, if no legal representatives appear to make such representations, the Commission will proceed with the evidence of Mr. Mainganya, and your client will be able to bring whatever application he intends to bring and to provide his version to the Commission in due course. Chair, the other thing I can update you on, which isn't reflected in this email, is earlier this morning, the other affidavit of Mr. Mainganya, as well as an affidavit of Mr. Rama, which will be referred to in today's proceedings, have been sent to Mr. Komane in response to his request. Chair, I'm not aware of any legal representative here today for Mr. Komane, and so it is my proposal that we continue with the evidence. And of course, we are eager to receive any information from any persons related to the mandate of the Commission. And if in due course Mr. Komane seeks to do so or makes an application to cross-examine any witness, we will place that before you, Chair, for determination.
Yes, and I see that on the last page of his letter, his attorney's letter, he does emphasize that he intends to give his full cooperation
Indeed.
to the inquiry. Just once again does make the point that the lack of notice, lack of time, and minimal admissible information against him is unfair and prejudicial. I think that the important thing is that he knows that the witness will be giving evidence today, and he has been advised that he could be here if he wishes to object. And he is not here, or his lawyers are not here. And whatever prejudice he may suffer, at least he will be given a chance to present whatever challenge he wishes to present. So I think it's okay, we can proceed, and he must simply be given whatever it is he's entitled to from the Commission.
Indeed, Chair.
That he might not have been given
Indeed,
yet.
and if what we've given him, in his view, is inadequate and there are further documents that are relevant, he will certainly engage with us on that.
Yeah, okay.
Chair, if I may then ask Mr. Mainganya's legal representative just to place herself on record before we proceed with the evidence.
Yeah. Please come forward.
Shall I walk up to here, Chair?
There, switch that off and go there.
Thank you, Chair. My name is Tabile Furman. I am the IDC's legal representative and therefore Mr. Mainganya's legal representative. I'm from Cliff Decker Hofmeyer, attorneys.
Thank you very much. Okay.
Thank you, Chair. If I may request the witness be sworn in.
Yeah. Please administer the oath of affirmation.
Please state your full name for the record.
Mark Pagamile Mainganya.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you will give will be the truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Yes, you may proceed.
Thank you, Chair. Chair and Mr. Mainganya, before I proceed with the questioning of Mr. Mainganya, with your leave, Chair, I'd just like to place today's evidence in context because it has been some time since we heard the aviation evidence.
It's been a long time.
Indeed.
Yeah.
And in order for today's evidence to make sense in the scheme of the evidence that was presented previously, if I may just take a moment to locate it. Chair, one of the investigations that was presented in the aviation session related to jet fuel supply agreements that had been concluded between South African Express and South African Airways with a company called EML Energy. You will recall we had the evidence of Ms. Luke and Mr. Vaughan. Both of them dealt with this particular jet fuel supply engagements with their respective state-owned entities and EML. Their evidence was that a jet fuel supply agreement had been entered into between South African Express and EML Energy in circumstances that did not follow procurement processes, at a time when the fuel was already being supplied to SA Express by SAA, and so it on its face appeared to be a duplication of supply. It was at a price 30% higher than the price that the SA Express was receiving fuel from SAA. And the further evidence of Ms. Luke was that EML, after it was awarded the contract for jet fuel supply, ended up never being paid for jet fuel supply because the only performance that it rendered was in relation to refueling and defueling of aircraft, which was in a small proportion. I think her evidence was about 80,000 rand, whereas the contract was for many, many more thousands beyond that. Chair, that was the background of Ms. Luke's evidence from the South African Express Airways side. What Mr. Vaughan gave us insight into was that actually prior to that South African Express Airways contract, there had been a decision of the board of SAA to set aside certain jet fuel transactions for certain identified parties. There was a process that was run to try and bring what were referred to as black industrialists into the jet fuel supply sector. And the consequence of that was that EML was one of 3 parties that were identified for that 20% set aside of jet fuel. As it so happened on Mr. Vaughan's evidence, despite them being shortlisted and recommended for appointment, they were not actually appointed in the initial 2016 tender. There was a later appointment of EML in 2018. So that is the context against which Mr. Mainganya's evidence is heard today. And it might not be readily apparent why we would be hearing from a witness from the IDC in circumstances of jet fuel supply to SA Express. But the reason for that, and it will be traversed with Mr. Mainganya in his evidence, is that off the back of these contracts with SAA and SA Express, a funding application was made by EML Energy to the IDC. And it received funding, and that funding transaction has been investigated and will be explored with Mr. Mainganya today. And so, Chair, with that background in place, if I may
Thank you very much
then
for that background.
commence with Mr. Mainganya's evidence.
Yes, which one of the
Right.
files should I should?
Chair, first of all, if we could just enter into the record.
Oh, yes.
There are 3 files comprising Mr. Mainganya's evidence today. They are all in the DD13 range, and they are files DD13A, B, and C. If we can enter those into the record.
Only one of them has got his affidavit.
Correct,
The rest are annexures.
correct. And other documents.
And other documents. The file that has Mr. Mainganya's affidavit or statement will be marked Exhibit DD 13A, and then there are 2 other files. They are leverage files. One will be marked Exhibit DD 13B, and that is the one whose first annexure is annexure VTR1, and the other leverage file will be marked Exhibit DD 13C, and that is the one whose first document bears the logo of IDC and is dated 30 January 2017, with the heading New Application. That will be Exhibit DD 13C.
Thank you, Chair.
Yes.
And we will spend most of today in DD 13A, which contains the affidavit, the first and second affidavit of Mr. Mainganya, but we will on occasion move to the other documents. Mr. Mainganya, so my suggestion to you, if I may, is to keep A readily available in front of you, and then when it's necessary to go to bundles B and C, I'll identify that. The second thing is just to ask that you put your microphone on, and we find that if you bring it closer to you, it sometimes amplifies a bit better. Thank you. Mr. Mainganya, could you, just for the record, clarify for us what your position is at the IDC?
My position is that of the Chief Risk Officer.
Thank you. And when did you join the IDC?
I joined the IDC in 2014, September.
Thank you. And what are your qualifications?
I'm a chartered accountant.
And before joining the IDC in 2014, what did your career involve?
Banking, risk management in banking. And before that, I was in public service as an auditor.
Thank you. If we can then just pick up the first page of your affidavit, and you'll find that at page 1 of the bundle DD13A. Ms. Mainganya, this is an affidavit, as I have it, that you deposed to previously, as compared with a statement. But just for completion's sake, can you confirm that this is your affidavit and that its contents are true and correct?
I confirm.
Thank you. And then if I can take you to your second affidavit that you provided to the Commission, you'll find that in the same bundle at page 32.1, 32.1.
Yes.
And can you just confirm for the record that that is the second affidavit that you provided to the Commission and that you confirm its contents as true and correct?
Yes, I do.
Thank you. If we can then just return to the first page of your affidavit, and that's at paginated page 1. I'd like to pick it up at paragraph 3 there. You've already told us about when you joined the IDC, but in that paragraph you go on to explain some of the committees that you serve on. What are those?
So some of them are the Special Credit Committee, the Credit Committee, and the Post-Investment Committee.
And you indicate also in that paragraph about a reporting line to you from the Risk Management Department. Can you explain to us how that works?
So the Risk Management Department reports to me. It is a second line function, so it is not directly involved in the transactions, but it assesses them before the transactions are submitted to the committees.
Thank you.
Just raise your voice a little higher if you can.
Okay.
Okay.
Ms. Mainganya, what I would like to deal with next, just for us to be able to navigate your evidence today and understand the IDC's processes, is to have your assistance in describing to us how the processes of the IDC work when it receives an application for funding. And Mr. Mainganya, I've been guided in that by an affidavit that was prepared by one of your former colleagues, Mr. Rama, which had also been supplied to the Commission. And for ease of reference, that appears at page 38 of the same bundle, A, that's DD13A. Can you confirm who Mr. Rama is and whether he's known to you?
Mr. Rama was an employee of the IDC. He was specifically involved in the chemicals business unit as a senior deal maker.
Thank you. And if you...
Sorry. It may be that your voice is soft by nature. Make another attempt to speak up a bit. Thank you.
Okay.
Okay.
So Mr. Rama was an employee of the IDC. He was a deal maker in the chemicals business unit.
Thank you, Ms. Mainganya. That's much better, I think.
Yeah.
So if we could continue in that frame for the rest of your evidence, just from an audibility point of view. If you go to the last page of that affidavit, you'll see it's the final page in the file in front of you, DD13A, and it's page 61. Could you just indicate for the record the date on which this affidavit was deposed to?
7th June, 2019.
Thank you. Now, what Mr. Rama does in this affidavit is to describe the end-to-end application process in the IDC. And so what I'd like to propose to do with you is to go to that and then ask you to explain it to us, but we'll just use the pointers in his affidavit for that purpose. And you'll find that at page 3939. It's the second page of his affidavit. And you'll see a heading there, end-to-end application process. Do you see that?
Yes.
Right, so he begins with what happens by the pre-investment business center at paragraph 5. Can you tell us about what that center does when it receives an application?
So that center would be the first recipient of applications from wherever they come from, especially in Gauteng. And then you have other applications that come from the regions. But that center in Gauteng essentially does a pre-assessment of the transactions. That is to check if, among other things, they are within the mandate of the IDC to fund, and to do a preliminary basic assessment before they are forwarded to the business unit for proper assessment. Yeah.
And what happens if an application proceeds past that pre-investment business center's evaluation? Where does it go next?
So it will go to the relevant department in which that unit falls. So if it's chemicals, it's sent to the chemicals business unit. Also, they assess the assessment that has been done to determine if they can proceed to do a due diligence on that application.
And there's reference to a person called a deal maker. Who is that in the structures?
So a deal maker would be the persons that would be involved in the due diligence, mainly in preparation of the transactions for submissions to the committee.
And could you tell us a bit about that due diligence process? What does it involve?
So there are, I would say, three distinct phases. It involves getting different expertise from the various people in the unit. So one person would, for instance, be a marketing expertise, one would be the technical expertise, one would be the financial. And then there are various other units that are involved in the due diligence. So for example, the environmental unit, which goes on to check the environmental compliance of the client. Then the other would be the legal department, which will review the legal aspects of the transaction. Then you also have the fixed assets valuation unit, which would value the assets. So all those people will be assembled for a specific transaction, and should it be assessed as readily passing for due diligence, that is the team that will go to the client and do a due diligence on the client.
And when the due diligence is complete, what is the next phase of the process?
So the next phase is that each member would compile his report, and the deal maker and the team leader in that unit would be appointed, and the team leader would compile the assessment, which is the submission now that should be serving at the committee from all the various members. And that assessment, that submission report would then be sent to the risk management department, which would do an independent assessment of that submission. And then they will raise various issues that they might have with the transaction. And then there would be a to and fro with the units where they try to address some of the risks that are raised by the risk management department. And then post that, if it's still proceeding, meaning if adequate measures are included in the submission to deal with some of those risks, it may be ready for submission to the credit committees.
And are the credit committees the ultimate decision-making bodies in relation to the application?
Yes, depending on the amount that is requested, it will go to various committees, all the way up to board committees, depending on the requested amount. If it is approved by that committee, that is a final decision.
Thank you. And can I just get one point of clarity? You spoke about the team leader producing the submission report, and then you spoke about that being evaluated by the Risk Management Committee. Is there also a peer review that happens before it goes to Risk Management?
Yes.
Right, so just so that I can get it right, the submission report is prepared. Then it is peer reviewed, is that correct?
Yes, and the head of the unit must also sign off on the report.
Right.
And the executive responsible must also sign off on that report, depending on the level.
Thank you. And can I say, just from the basis of what you've described now, it sounds like a multi-staged process with various endeavors to ensure accuracy in the process. Is that a fair description?
Yes, we try to do that.
Thank you. And then after a decision to fund has been made, there's been reference to a post-investment committee. How does that committee become involved?
Okay, so after a decision is made, it does happen sometimes that various amendments to the approved transactions are requested. So that committee is mandated to deal with those amendments. It is composed of 4 executives, which all the time one of them would be the executive in which the application comes from. So each member of that committee assesses the request. It's not a committee that sits and discuss. So the submission is sent electronically to each member, and they assess the request, and they either grant an approval or not of the requested change.
And do they generally do so quite swiftly after the submission? Is there a sort of time frame on resolving the request?
Yes, so the committee was formed specifically for that purpose, that we may deal speedily with requests that come from the client. And hence it's electronic. It goes at the same time to all the members. Yeah.
And do you have a sort of sense of the average time? Are we talking about days after receipt?
I don't have the average time, but each member tries to process it as and when they receive it.
Thank you. When it becomes relevant, I'll seek clarity on the timing in relation to the specific decision that the Post-Investment Committee made in this case.
Okay.
If we may then go to this particular application for funding, and you'll pick up how it originated in the IDC, again in Mr. Rama's affidavit, and that would be at page 41 of bundle DD13A. And you'll see at the first paragraph on that page, paragraph 11, Mr. Rama describes how he received the EML, that's a reference to EML Energy Business Plan. Could you read there what he records?
So he says, I received the EML business plan from Mr. Billy Kobina, a senior account manager in the Development Funds Department, via an email of 17th of May 2016. He introduced the application to me. The email trail within Mr. Kobina's email suggests that the email originated from Mr. Edward Komani, the Divisional Head, Industrial Investment Facilitation Economic Department.
Thank you. And if we could go and take a look at that email, you'll now need to move to DD13B, and it's right towards the beginning of that file.
Sorry.
So if you go to the DD13B, it will be one of the other files next to you on your left.
What's the page?
The page 63, Chair.
Okay.
63. Could you please describe for us the email that appears in the second half of that page, who it is from and who it is to?
So it's from Edward Komani. It is to Billy,
Could you give the full name, Billy?
Billy Kobina.
Chair, just for the record, Kobina is spelled Cobbinah. And
Yes.
Mr. Komani, that's Edward Komani, Komane. Mr. Mainganya, on what date was that email sent?
May 17, 2016.
Thank you. And if you could just read for us what it says.
It says, "Hi, Billy. As discussed on the phone now, see attached and let me know if you need any additional information."
And signed off by?
Edward Komani.
Who is Mr. Billy Kobina?
Mr. Billy Kobina was an employee of the IDC, employed in the development funds unit within the IDC.
Thank you. And then if you go to the top of that page, there is an email between what I understand to be Mr. Kobina and Mr. Rama. Can you tell us when that was sent?
That was sent on 17 May 2016.
It appears to be shortly after the email that was sent from Mr. Komani to Mr. Kobina. Is that correct?
That's correct.
And what does Mr. Kobina say to Mr. Rama?
Can you do this deal first for a potential client? I've asked for the audited financial statements.
Thank you.
Just to get some things correct, you've got the ITC, and then you have got divisions within it. Is one of its divisions industrial investment facilitation?
No, Chairperson.
Is that something else?
That is where apparently Mr. Edward Komani works. It's the Economic Development Department, but it's not of the IDC.
Repeat the last sentence. It's not.
It's not a unit of the IDC.
Oh, okay. So that's outside of.
It's outside.
Okay. Okay. No, that's fine.
So just so, for my own clarification purposes, can we understand these emails to be a third party, Mr. Komani, sitting outside the IDC, forwarding something that he had discussed with Mr. Kobina to him? Is that as you understand the bottom email?
That's what the email says, yes.
And then the higher email is between two IDC employees, as I understand it. It's Mr. Kobina then forwarding it to Mr. Rama, both of whom are IDC employees, correct?
That's correct.
Thank you.
And just repeat what Mr. Kobina's position was. You did, I think you did say it earlier on.
Yes, Chairperson. He was employed by the IDC in one of our units called Development Funds Department.
Oh, okay, you didn't say what his position was. Do you remember what his position was?
I think it was a senior account manager.
Okay, no, that's fine. I'm sure we'll find it at some stage.
Indeed.
Yeah.
Thank you, Chair. If we can then just move ahead to the actual decision that was made in relation to this funding. But before we leave the page that we're on, I do just want to indicate, Chair, that Mr. Komani's email at the bottom refers to seeing attached a document. If you go over to page 65, you'll see that that is the attachment to the email. And what I would like to just draw to the attention for the purposes of the record, because it will become relevant later in the evidence of Mr. Mainganya, is at page 71. Well, sorry, let's start at 65. What is that document, Mr. Mainganya?
It says Business Plan 2016.
And whose business plan is it?
At the top, it's got EML Energy.
Had you seen this document before?
No.
If we move in the business plan to paginated page 71, you'll see a heading there, product and services. Do you see that?
Yes.
Can you read for us what EML Energy indicates there in the business plan are its products and services?
It says EML Energy is selling Jet A1 and offer the following services: refueling, defueling, calibration, storage, maintenance, and repairs.
Thank you. Can you just explain to us what would a business plan of this nature from a potential applicant for funding then, how would it be treated then by the IDC?
So remember, I referred to the pre-investment business center. So a business plan like this would have gone to that center for evaluation before it goes to the business unit.
And who would be the person who did that evaluation in this case?
You mean in any of the people you've mentioned so far?
Yes.
At the pre-business center?
Yes.
It would have been none of these people so far.
Right. If we can then just jump ahead so that we orientate ourselves in time, as I have it, this email with the application and the business plan comes through in May of 2017. There is a final decision to approve this funding on the 6th of February 2017. So I'd like to jump ahead to that, and then in the evidence we'll go through the stages towards the decision. But it's quite useful for us now to understand what the decision was, if we may. And you'll find that decision in the same bundle D, that's DD13B, at page 264. Ms. Mainganya, as I understand it, this is the minutes of the meeting at which the decision in relation to EML's funding application was taken. Is that correct?
That's correct.
Just explain to us when that was.
6 February 2017.
Were you involved in this decision on that day?
I was not involved. Yeah.
I can see down the page under the heading apologies, it appears you gave your apologies for not having been present. Is that correct?
That's correct.
So would you ordinarily be on the committee that was deciding this application?
That's correct.
But as it so happened, you weren't there on that day. Is that
No,
right?
I was not there.
Thank you. And then if you go over the page to 265, what is that?
This is the funding request by EML.
Is this what was decided by the committee in relation to the funding? If you see under the heading 3.1 EML Engineering and Construction PTY Limited EML, it says the committee was requested to approve the following. Do you see that?
Yes, I see that. So, okay.
Is this what they did approve?
This is what was requested, what was approved. It's on the following page, the
Thank you.
decision. Yeah.
Thank you. If we could just take a bit of time with subparagraph 1 of 3.1 on page 265. I'd like to understand the two facilities in respect of which funding was sought. Can you explain to us what the first facility was, which you see under subparagraph 1 on that page?
So the first facility was for working capital. That was for 6 million. That was requested to be funded under the MSEP program, which the IDC manages.
Chair, we will come back to explore what MSEP means.
Okay.
But for present purposes, thank you, Mr. Mainganya. And tell us what the terms of the loan was going to be.
It says the loan will be used to fund working capital and will have a term of 42 months, 6 months capital moratorium, and sculptured payments as follows. Installment 1 to 12, 220,000. Installment 13 to 24, 120,000. Installment 25 to 36, 160,000. Repayments will be in 35 installments of 166,000 and a final payment of 190,000. Interest will be at 4%.
Thank you. So can I just clarify there? I understand a term of 42 months, I had to do a quick calculation in advance of today's evidence, is 3.5 years. Is that right?
Yes, yes.
And those payments that you see 1 to 12, 13 to 24, and 25 to 36, are those monthly payments?
Yes, these will be monthly payments.
So when it says 1 to 12, that's month 1 to month 12, is that correct?
Yes, yes.
Over the period. And so the full period, if you add the 6-month capital moratorium, would be 3 years plus 6 months, which is 4 years. Is my understanding correct?
Which is 42 months.
Well,
Sorry.
42 months is 3.5 years. Is the capital moratorium within the
42 months.
Excellent. So the full term of this loan is 3.5 years, the 42 months.
The 42 months, yes.
Thank you. And then tell us about the second piece of funding that was approved.
So that was a 6,500,000 plant and equipment subordinated loan facility to be used for the upgrade of plant and equipment and the purchase of Bowsers. The facility will have a term of 5 years and is expected to achieve a 13.8% real after-tax return. Repayments will be in the form of cash sweeps from year 2021 to financial year 2024, maintaining a minimum cash balance of 1 million, with cash sweeps occurring every 6 months, beginning 28 February 2018.
Ms. Mainganya, can you just confirm for me, what was the term of this plant and equipment loan?
5 years.
Thank you. Then can you help me with something? Because this was approved in 2017, is that correct?
Yes, Joe.
We're in February 2017, as I recall it.
That's correct.
So a 5-year term would take you to 2022, is that correct?
Yes, sir.
So help me with the last sentence there then. It says repayment will be in the form of cash sweeps from financial year 2021 to 2024, maintaining a minimum cash balance of 1 million. Isn't 2024 beyond the term of the loan facility?
So the term of the loan facility would start from 2021 in terms of repayments. It will start from 2021, 22, 23, 24. So it doesn't start from February 2017. The repayments thereof only start from 2021.
We'll look at that. Is that your clear understanding of how it works?
Yes, so from the date of approval until 2021, there are no cash sweeps.
But there are repayments preceding that, is that right?
So the repayments would only occur if there's cash, but contractually the client is obliged to start repaying from 2021.
Okay, we'll need to explore that a bit further when we go to the cash flow statements that were prepared by the finance department, because the understanding you've given now does not accord with my understanding of that schedule, but you may be able to clarify for us. But as you understand it here, it's a 5-year loan for plant and equipment, and that is a loan that they received the cash for in February at a point in 2017, correct? Mm-hmm. And as you understand it, did they only have a repayment obligation that began in 2021?
Yes.
Okay, thank you. And then over the page at 266, can you assist me there? Is it your understanding that those 2 loans were then approved?
Yes, that's correct.
And just deal with paragraph 3 at the top of that page, if you will. There was another facility sought and approved. What was that?
So it's a guarantee facility of 62 million to Total South Africa and 3 million to Engen Africa for Jet AWOL relating to the SAA contract. The facility will have a term of 12 months.
Thank you. Mr. Mainganya, I'd then like to go back to the topic of MSEP. And for that purpose, I'd like to move to page 2 of your affidavit. Now, you'll recall your affidavit is in DD 13A. Mr. Mainganya, at page 2 of your affidavit, you'll see halfway down, there's a heading 4.1 in bold, Manufacturing Competitiveness Enhancement Program Qualifying Criteria. Is Manufacturing Competitive Enhancement Program abbreviated as MSEP?
That's correct.
And please tell us what that is. What is?
Hang on one sec.
Apologies,
I
Chair.
haven't got to the right page. What's the right page on his affidavit?
His affidavit, page 2.
Page 2, okay.
Apologies, Chair. So we're midway down the page, and we're dealing with the heading in bold there, Manufacturing Competitiveness Enhancement Program. What is that program, Mr. Mainganya?
So MSEP is a program of the Department of Trade and Industry, for which some of its funds are managed by the IDC. The IDC's Development Funds Department is a custodian of the MSEP program within the IDC, and it assesses applications for funding from the MSEP program prior to these applications being submitted to the various IDC committees for approval. I am informed that MSEP is aimed at assisting manufacturing or value-adding companies that need funding for working capital, or companies with at least 51% BE shareholding that need capital equipment. MSEP is priced at a rate of 4%, fixed for 4 years for working capital and 7 years for capital equipment, among other criteria. MSEP is not available for startup companies. MSEP is only applicable to manufacturers under Standard Industrial Classification Code 3.
Mr. Mainganya, do you mind if we just stop there for a moment? I'd just like to get a little bit more clarity in relation to the working capital loan that was approved for EML Energy that we just looked at. Did I understand you correctly to say it was approved under this MSEP program? Is that right?
That's right.
And if we can just pause at that 4% fixed interest rate, is that a preferential rate?
It is.
What would the ordinary rate be if you didn't qualify for MSEP funding?
So this client was priced at prime plus 3.
Right. And that was the interest rate on the plant and equipment loan, was it not?
That's good. No, it was 4%. But if there was no MSEP, it would have been prime plus 3.
No, I was talking about the plant and equipment loan. The second loan was priced at the subordinated loan at prime plus 3%, wasn't it?
No, it was not. It was priced at 13.8%.
Right. What was that? Prime plus what at the time?
No, this is a different mechanism. This is a real after-tax return. It's not linked to prime.
Oh, I see. So where is the prime plus 3%? Where does that come from?
So for every facility, whether it qualifies for MSEP or not, we calculate what the IDC pricing would have been had it not qualified. So for this client, it would have been prime plus 3.
Thank you. So at the time, 2017, do you recall what prime was?
No, I don't.
If I said to you it was around 10%, would that sound right?
So it's in the schedule that we redacted, yes, yeah, around
Yes.
10%, yeah.
Thank you. So that means you're comparing a difference of about of 4% with 13%, correct?
That's correct.
Thank you. Then if we can go on, because you were going to deal with the criteria. So as I understand your evidence, MSAP is something that you must qualify for to get this preferential rate. Is that correct?
That's correct.
And then there are qualifying criteria. Is that right? And the first of those you indicated at the bottom of page 2. What is that?
It says only applicable to manufacturers under Standard Industrial Code Classification Code 3.
Thank you. Can I ask you what your understanding of Standard Industrial Classification Code 3 is?
So the MSEP program has various codes. This should actually be level 3. So level 3 would have many subcategories under it, classifying each industry according to where it comes from. So if it's under 3, there will be various industries falling under 3.
So just what is a standard industrial classification code? Where does that come from?
I stand under correction, but I think this is a universally used industrial classification code.
If I could take you to, in that same bundle, page 37.1, 37.1, you'll find it just before Mr. Rama's affidavit commences. This is a SARS document reflecting standard industrial classification codes. Is that what MSAP is referring to when it talks about standard industrial classification codes?
I think so, but MSAP has its own codes, has its own classification, which are not grouped according to this one.
Do you know that as a fact?
Yeah, yes, I've got them here.
Oh, we haven't seen those, so maybe what you would need to do is assist us over the tea break to make those available to us.
Okay.
What then, until today we had understood these to be the standard industrial classification codes, the ones that you see at 37.1. What is code 3 under the standard industrial classification code that you understand to be the MSEP code?
So, so the one I've got here, it says the DTI, SIC codes, Manufacturing Competitiveness Enhancement Program, MSAP. Then it lists Standard Industrial Code Level 3, and then under Level 3, it lists various industries, starting from 301 all the way to 395.
Thank you. Ms. Mainganya, I have not seen that before, so I'd like to take a look at it over the break, and then we can come back to this point, if we may, in your evidence.
Okay.
If we go over to page 3, where you were at the top bullet of your affidavit, you give the other qualifying requirements, which are not pertinent for our purposes. But at B, you tell us that the EML application was pre-assessed to have met the MSEP requirements. Is that correct?
That's correct.
Who did that assessment?
It was done by Mr. Billy Kobina.
And what was the basis he gave for identifying it as having qualified for MSEP funding?
So in paragraph C, I say, subsequent to my meeting with the Commission's legal team above, and for purposes of preparing this affidavit, I interviewed the IDC's Mr. Billy Kobina, who pre-assessed the EML transaction to determine whether it qualifies for MSEP. He indicated that he approved and recommended the transaction for MSEP on the understanding that EML will, as part of its operations, be involved in blending and value adding on some of its products.
Thank you. I don't want to jump to 2018 yet, if we may. That's why I've stopped you there, because I just want to stay faithful to the chronology at this point. This fact that it had been qualified for MSEP funding was referred to in the submission that was made to the committee that took its decision on the 6th of February 2017. And so I'd like to take you to that document so that we could explore it a bit, if we may. You'll find it in DD 13C, so it's one of the files on your left-hand side. And we are looking there at page 554, which is right at the beginning. What is that document, Mr. Mainganya?
So this is a submission to the Special Credit Committee.
Is that the committee that made the decision on the 6th of February?
That's correct, that's correct.
And in the scheme of the processes of the IDC, what is this document?
So this document is a basis on which a funding decision is made. It contains the requirements of the client. It tells what facilities are required. It describes the business, what it's going to do. It describes the industry. It summarizes the due diligence that was done. And based on that, it recommends to the committee that the facilities be approved.
Thank you. I'd like to pick up a few aspects of the submission because they will be relevant to the further evidence that you give. And if I could then ask you to go to page 557 in that document. The third paragraph on that page deals with a fuel farm that EML Energy had. Can you tell us about that?
So it was indicated in the submission that Dinel had donated a fuel farm to the client. It is the premises on which the client was conducting its business.
Thank you. And in this paragraph, the compilers of the submission are dealing with the valuation that was given to that fuel farm. Can you tell us about what is recorded there?
So it says EML had later revalued the assets using an independent valuer to circa 14.3 million. However, the assets were valued by the IDC's evaluations department at 7.4 million.
Thank you. We'll pick that up later, but just so I can understand, does that mean EML in its books had given it a particular value, but when the IDC did its due diligence, it gave it a different value, a lower value?
That's correct.
Thank you. If we then go to 559, the second paragraph there talks about the tender that EML had been involved in to supply jet fuel to SAA. Is that correct?
That's correct.
And what is recorded in that second paragraph about that tender?
It has been established that there are 3 finalists for the tender. The budgets have been set up in a manner where it has been assumed that EML will be awarded a third of the full tender as per discussions with SAA. To remain prudent within the budget as the allocation of the tender has not yet been provided, should a larger amount of the tender be awarded, this will increase sales and net profit further.
Thank you, Chair. I note that we have just gone past 15:15. It may be an appropriate time to take the break.
Yes, let's take the break, but we'll take a rather longer tea break today. Let's resume at 11:45.
Thank you,
I just
Chair.
need to attend to something.
Well, it'll also facilitate us looking at the document. Thank you so much.
We adjourn.
All rise.
Okay, let's proceed.
Thank you, Chair. Mr. Mainganya, we were on page 559 of bundle DD 13C when we broke for the break. And I was asking there about the second paragraph on that page, where it is recorded that in the submission to the the committee that was deciding this application, that it had been established that there are 3 finalists for the tender. That's a reference to the SAA tender. Is that correct?
Yes, that's correct.
And then what is your understanding of what else is recorded there about the stage in that tender that EML was at the time that this funding decision was taken?
Sorry, the question is?
The submission indicates that the tender process had not yet been finalized. Is that your understanding of it?
Yes, that's correct.
What does it indicate was the stage of the tender process that had been achieved by the time this submission was made?
So the tender had not been approved at that stage. It was still adjudication.
Indeed, but it does go on to say the budgets have been set up in a manner where it has been assumed that EML will be awarded a third of the full tender, as per discussions with SAA. Let's just stop there. If a tender process hadn't been completed, how could it be that any reliance was going to be placed on what volumes EML would be awarded?
So in the submission, the team says in doing their marketing due diligence, they interviewed SAA, and SAA at that stage informed them 3 bidders had been shortlisted, and one of them was EML. And they also informed them that maybe the allocation will be equally among the 3. So the team had to make assumptions in doing the financial model. Therefore, they took the 20% of liters that was earmarked for triple BE suppliers and divided it equally among the 3 shortlisted bidders as an estimation to do the financial model.
Is that a customary approach for the IDC, that it would assess an application prior to the tender in fact being awarded?
Yes, sometimes it does happen that when a client comes, it's still bidding. But the tender requirements, for example, would be such that when it's awarded, it need to buy certain equipment. Therefore, clients would come to us and say, I've bid for this thing. The requirements that I will need working capital. The requirements are that I will need to prove that I have financial means to buy, in this case, the jet fuel from the suppliers. Therefore, we would adjudicate that, but as a condition of our approval would be that the disbursement of the facilities can only be done once confirmation of the tender has been awarded. So it does happen.
And just in terms of how you assess the viability of the application, is it customary to rely on representations from a state-owned entity about how much is going to be allocated to a particular bidder?
So in conducting the marketing due diligence, the team indicates that it wanted to verify the assertions that the client had made. So the client had said, I've put a bid for this tender at SAA. Therefore, as part of DD, the client wanted to verify that and ascertain the fuel requirements from SAA and ascertain what the client was saying with regards to the allocation for BEE suppliers.
But
I'm sorry, Please just try what you tried earlier on when we could hear you quite well. Just try that again.
Okay.
Okay, but it's fine. You can continue. You don't have to go back to the answer you have given.
Okay.
Thank you, Chair. Mr. Mainganya, do you know who the due diligence team of the IDC dealt with at SAA on this question?
So in Vimal's affidavit, it does indicate. I just can't call the name now.
I think it was Mr. Sokwazile.
Yes,
Does that ring a bell?
Yes, ring a bell, yeah.
And do you know what position he held in SAA?
No, I don't.
Is it any cause for concern for you that reliance was being placed on a particular allocation of the 20% to EML in circumstances where the approval processes within SAA had not yet been completed?
Yes, in our risk report, we did raise that risk, that there's a risk that this tender might not be approved. So it was a concern.
Well, I'm interested in a slightly different thing. I know that you identified a risk, and you also identified a risk in relation to how long the tender was going to be awarded for. But this is a slightly different thing. This is the IDC going to a person within SAA and saying, how much is this tenderer going to be awarded so that we can do our cash flow forecasts on the business? Is that customary?
So what is customary is to verify the assertions made by the client. I don't know to what extent, in this case, the client revealed the tender processes. So in his affidavit, he indicates that before the client could talk, it was required that a non-disclosure agreement be signed.
Sorry, who is he?
Vimal.
Mr. Rama.
Yes, Mr. Rama, that a non-disclosure agreement be signed so that confidential information regarding this process may not be disclosed.
And that was a non-disclosure agreement between SAA and the IDC,
Yes,
is that right?
yes.
Because certainly the client couldn't know anything about that process, could it?
Yes.
And then you go, the submission goes on in the last sentence on page 559 to say, should a larger amount of the tender be awarded, this will increase sales and net profit further. Do you see that?
Yeah,
That means it would be better for EML rather than worse, correct?
that's correct.
Couldn't it also be that a smaller amount of the tender could be awarded?
It could?
But that's not reflected here, is it?
No.
If we can then go to page 564. When the decision to approve the funding was made on the 6th of February 2017, there were certain conditions precedent that applied to that funding. Is that correct?
That's correct.
And the one I'm interested in, we can pick up at the bottom of page 564. Can you tell us what those conditions precedent relate to in the last block of that page?
So condition number one.
Well, before we get there, what are they conditions precedent for? That's
Okay.
the underlined second line.
Okay, so you'd remember 3 facilities were approved, which is a working capital facility, the subordinated loan facility for equipment, and the guarantees. So these conditions are for the loan, for the subordinated loan, and for the guarantee. So they are conditions precedent for all the facilities that were approved.
Thank you. And if we could just focus on the second one.
So the second one says there must be a signed off-take agreement between EML Engineers and Construction and South African Airways with the terms to IDC's satisfaction.
Why do you understand that was put in?
I'm sorry, I thought I understood where you were. I thought it was the last block at page 564.
Correct, Chair. We were at point 2 in that last block.
Oh, okay.
Thank you. and that related to the requirement that there be a signed off-take agreement between EML and SAA with terms to the IDC's satisfaction. And Mr. Mainganya, I was just asking you, what is your understanding for why that was included?
It's because it is a key basis on which the funding application was made.
What risk is sought to be protected there for the IDC?
So it's the risk you just raised that it may happen that the client is awarded fewer liters than the one that are modeled, which would mean based on those liters, the client cannot afford to repay the facilities. So IDC needed to be happy with the allocation that the client had got before it could proceed with the transaction.
So is it fair to say whatever terms were arrived at were important for the IDC to interrogate?
Yes.
Then if we can go over to page 570, and this is the document that reflects the point that you made earlier about the risk committee having identified a concern in relation to the tender. Just to help us, remind us in the processes, when does this risk committee get involved?
No, remember I indicated that when the submission has been compiled by the business unit, it is then sent to the risk department to assess the application. Then the risk department writes a report of that assessment, and it attaches to the submission to the credit committee.
Indeed.
So this is the risk report.
Thank you, Ms.
produced by
Mainganya.
the
That's
unit.
exactly as I understood it, and I'm indebted to your explanation for it. So the committee that's deciding whether to approve this funding is not only getting the submission prepared by the leader of the particular unit where the analysis has been done, but they also are getting the risk department's appraisal of that submission, correct?
Yes.
And if we could then look at the first heading on that page, which is entitled Material Risk Considerations, and it's the second bullet there that I'm interested in, which is highlighted as the material risk. What was that risk?
So the risk says the tender was issued for a period of 3 years. However, based on discussions with SAA, the tender may be extended for 5 years. The risk remains that the tender may not be awarded for 5 years, resulting in a mismatch between the IDC loan tenor and the awarded tender. Furthermore, should the tender be awarded for 5 years, it may expose the IDC to financial loss, as the tender may be challenged by any other bidder and could be rendered unenforceable in terms of the PFMA. This will expose the IDC.
So can I just pause there? Are we to understand from that that the assessment of the contract that was used, should it have eventuated, that was used to assess the financial viability of EML as a recipient of this funding, was based on a 5-year contract from SAA?
Yes.
And that is despite the fact that it was known to the IDC that the tender had only been advertised for 3 years. Is that correct?
That's correct.
Again, my concern is a similar one to the previous one. Why would the IDC be comfortable in assessing the financial viability on the basis of a term for the contract that hadn't been the advertised term?
Okay, so at this stage, when the decision is made, it is not known how many liters the client has got and the allocation. So the modeling is based on a 5-year period, since the facilities are 5 years, but the tender is for 3 years. So when the tender is eventually awarded, it will then have the exact allocation of the liters that are given to the client. And based on that allocation, then the IDC would determine if it proceeds with the facility or not.
But why model on 5 years when, to the knowledge of the IDC, the tender was only for 3 years?
So remember the main facilities that are granted for for purchase of fuel is the guarantee. So that one is modeled for 12 months. It's a short-term facility. Then there are two other facilities. One is for working capital, one is for equipment. Now, what is normal is the equipment, you would model it along the lifetime of the equipment, because those facilities are secured by the underlying assets. So those are the considerations that were taken into account in doing that.
And the working capital loan?
The working capital loan was for 4 years. So in the submission, the team indicates that should the client allocation be for 3 years, the remaining facility at that point in time would be a minimal. Therefore, the IDC took a view on risk on that remaining facilities could be serviced by other revenues other than the SAA contract, because the client was already trading.
Where is that?
Is that something he could check over lunch?
Possibly. Let's do that, Chair.
Yeah.
I raise it, Mr. Mainganya, because I have not found that in these
I'll check
documents.
it. I'll give it to
So it would be useful if you could check that for us. Assuming that it's not there, though, would it not be more prudent to model for the purposes of financial viability assessment on the basis of the known tender period?
Yes, ideally we should match the funding. Yes.
And then if we can go over to 571, you'll see at the bottom there's a heading pricing. Do you see that? Apologies, 571. So there's a heading at the bottom, pricing. Do you see that?
Yes.
And just read for us the first bullet there.
So working capital loan, client qualifies under MSEP, alternate pricing equal prime plus 3 using decision support 2.
Thank you. And that's a recordal of your earlier testimony as I had it. You said if they hadn't qualified under MSEP, then the alternative pricing would have been prime plus 3, correct?
Okay.
This indication that the client qualifies under MSEP, do you see that?
Yes.
Do you know if anywhere else in the submission it was indicated to the decision-making committee the basis on which it had been determined that EML Energy would qualify under MSEP?
No, I can only think of reference to value-adding part.
Right. And is your recollection that that may be somewhere in the submission?
Yes, yes, yes.
I understand, Mr. Mainganya, from your affidavit that, and we looked at it just before we went to this document, that when you went to Mr. Kobina after your engagements with the Commission and you asked him why he had qualified EML for MSEP funding, he told you, and I'm quoting here from page 3, you don't have to go there for present purposes, but as I read it here, he said to you, he approved and recommended the transaction for MSEP on the understanding that EML will, as part of its operations, be involved in blending and value adding on some of its products. Is that what he told you?
Yes, that's correct.
If I tell you that I have read this submission very closely, it doesn't mean that I do so always without error, but I've read it very closely and I have not found any reference to blending or value adding in it. Would that surprise you?
It wouldn't, but there's reference to value adding.
There is.
Yes.
Could you take me to that?
Okay. Can I refer to my notes here? It's quick.
Indeed, certainly. If we can do it quickly, then maybe we do so now. Otherwise, Chair, with your leave, we can maybe pick these two aspects up after the break.
Yes.
Just so that we
yes.
don't delay ourselves
Yeah.
too much. Ms. Mainganya, should we leave it for the break? Would that be preferable? But just so I can understand where we are, you agree with me that there's no reference to blending anywhere?
Yep.
But you do recall a reference to value add, and you'll find that
Yes,
for me.
yes.
Thank you so much. We now should go to the document that you made available to the Commission over the break. Chair, we've managed to make a copy for yourself, if I may beg leave to hand that up.
Yes.
Chair, it's a copy that Mr. Mainganya had with him, and so it does have some handwritten annotations of his. He's happy for us to work off this document now, notwithstanding those annotations, but he's going to provide us with a clean copy for when
Okay.
it goes into the record.
Okay.
Chair, my suggestion is that we slot it in after the codes that we had thought were applicable, and that would mean paginating it at page 37.3. If that's suitable. Otherwise, we could give it a different exhibit number. I'm in your hands on that.
Let's make it 37.3 if you think that should work.
I think it will, because then it
Yes.
comes in the right place
In the
in the
right place,
documents.
yeah.
But we can just work with it separately now.
Yes.
We will replace the clean copy in your
Yeah.
bundle as
Okay.
well, Chair.
Thank you.
So, Mr. Mainganya, I understand your evidence earlier to be this is the applicable set of standard industrial codes that applies to MSEP. Is that correct?
That's correct.
We're indebted to you for pointing that out to us this morning. Tell me which of those codes it was determined applied to EML?
It doesn't say, but the only one I could see that refers to petroleum is code 332, petroleum and synthesizers.
So if we go down, there's a column, the third column is SIC code, and then we read the first one of those is 0301. If we move down to 0332, is that the one you're referring to? The
Yes.
one you've ringed actually in
Yes,
pen?
yes.
Is that what you understand Mr. Kobina determined, or is that you looking at the code and working out what it might have been?
It's me looking at the codes, because, so if you look at that codes 332, it also have subcodes between under it, which I've indicated there, but the submission, and he didn't indicate which of those particular codes applied to this.
But EML was neither a refinery nor a synthesizer, was it?
No, it doesn't say so in application,
Yes. So why would you identify that as the applicable one?
because the subcodes talk to crude petroleum.
I beg your pardon?
The subcodes that I've referred to talk to crude petroleum.
Crude petroleum.
Yes, yes.
Okay. Could you get us those subcodes over the break?
Okay.
Thank you. Right. Subsequent to you interrogating this pre-assessment of the EML funding qualifying for MSEP with Mr. Kobina, you then, I understand, and that's if we go back to page 3 of your affidavit, at paragraph C on that page, Chair, that is in DD 13A. We're back in the smaller file.
Yes, page 3 you said.
Indeed.
Okay.
And I'd actually like to pick it up at D on that page. You say at D there, Mr. Kobina subsequently informed me on the 23rd of May this year that the DTI in an email correspondence dated 3 May 2018 had confirmed that fuel storage and blending is not covered by the MSEP program. Do you see that? Mm-hmm. Was EML ever doing anything other than fuel storage, to your knowledge?
No.
So in May 2018, if I read this, and correct me if my understanding is incorrect, in May 2018, the DTI confirmed that EML would not have qualified for MSEP funding. Is that right?
So in my supplementary affidavit, this is a point I'm referring to.
Let's go there.
Okay.
You'll find that at page 32.1 in the same bundle, 32.1. That's the commencement of your supplementary
Yes,
affidavit, is
yes,
that
yes,
right?
that's right.
Mr. Mainganya, and then if you go over the page to 32.2, that is where in paragraph 5 you deal with MSEP, is that correct?
That's correct.
And what did you want to tell us about that?
So I wanted to clarify that that confirmation from the DTI was referring to a different transaction because the IDC was considering a different transaction and it requested confirmation from MSEP, from DTI, whether that would apply. So the response in that email was confirming that it wouldn't apply.
Yes, I understand that. But if the DTI, admittedly in relation to a different funding application, in May of 2018 said fuel storage doesn't qualify for MSEP, that would, I assume, apply to any application for funding based on fuel storage, correct?
That's correct.
And EML was never doing anything other than fuel storage, correct? Yep. So it wouldn't have qualified when it was pre-assessed by Mr. Kobina.
Yep.
Sorry, just say that for the record.
Yes, I agree.
Thank you. Thank you. I would then like to move, if we may, back to your affidavit. And just to conclude the question of MSEP, is it fair then to say that the committee relied entirely on Mr. Kobina's pre-assessment that this funding application qualified at least on the working capital loan for the preferential MSEP rate?
Yes, he's the one who did the assessment. Usually the team would also motivate during the meeting as to why it deems it qualifying.
Did they do that to your knowledge?
I cannot confirm, I was not there.
Indeed, you weren't present,
yes,
were you?
Yes.
Have you done anything to investigate whether there were justifications given, or whether the committee just relied on that sentence that we read at page 571? You don't need to go back there, but the sentence just stipulated client qualifies under MSEP.
I cannot confirm if there were discussions on that one.
Thank you. I'd then like to move to page 4, I think that's where we were, and look at the engagements with South African Express. We have traversed this a bit already in your evidence because we were dealing, when we looked at the submission that went to the committee, with some of what I'm going to suggest are curious features of the way in which the SAA tender was approached by the IDC. And you'll recall the issues we traversed there was taking a funding decision despite the fact that the tender hadn't been approved, and you've given your comment on that, and then deciding to run a financial viability model on a 5-year contract in circumstances where the tender was only for 3 years. Is there any other aspect of the engagements between the IDC and SAA that you would like to comment on?
Not at this stage.
Thank you. Well, then we can go over to page 5, because there we deal with the financial viability assessment that was made of the EML application. And you'll pick that up under the heading of 4.3 in bold on that page. For this purpose, Mr. Mainganya, we're going to need to look at the cash flow model that was produced by the relevant team, insofar as it was submitted to the committee. Now, it's in the bundle, C, Chair, but what I've done for today's purposes is just provided us with bigger copies, because there are lots of numbers on the page and it's just easier to see. So if I may beg leave to hand it up. Chair, this is a duplicate of the page in the bundle, and my suggestion is just for today's convenience, we work on the A3. Okay. I'm handing up 2 pages.
Thank you.
The idea is that we work with them together if we can. They come from different parts of the bundle, so just for record purposes, the one page is paginated MPM 576. That's actually the one we need to start with, and it appears in DD 13C. And then the second one I want to work with, Mr. Mainganya, appears in your affidavit. Well, it's an annexure to your affidavit, and that is paginated MPM 21, and that is in DD 13A. But for ease, we will work on, I understand you've also been given a larger copy, Mr. Mainganya, and your legal representatives as well. I will work on my smaller copies because we seem only to have received 3. Mr. Mainganya, the document at 576, what is that?
During the discussions with the legal team, it was identified that there was an error in the cash flow.
Oh, before we get to the error, can we start with 576?
Yeah.
Sorry, and I should assist you. 576 is the cash flow statement that appeared in the submission that was approved in February 2017.
Yeah.
Right. So I just want to know what this document is, right? What is it?
Okay, so these are the cash flow projections derived from the financial model. They are used to determine the repayment, the ability to repay the facility.
Thank you. So just in layman's speak, I assume the people in your finance department will look at the application for funding, how much is sought, will look at the position of the business, its cash flow, and will determine whether on the terms for the loan that are being proposed, the loan will be serviced. It will be, the company will be in a position to pay it back. Is that a fair summary?
That's correct.
Thank you. So if we can just look at this page, because for those of us that don't work with these spreadsheets often, it sometimes requires a little bit of deciphering. First of all, just read for us the heading of the document.
So 576, it's EML Energy Consolidated Cash Flow Statements for the years ending 28 February.
Thank you. And then below that, there's an underlined rand denomination with an apostrophe and 3 zeros. Can you explain to us what that means?
Thousands.
And let me just ask you here, I understand that to signify that when we look at the table, right, we've got a whole lot of numbers there. Those are, other than where it's a date indicated, those are rands. Is that correct?
Yes.
So it's money being signified, funds. Yeah. Right, but often those numbers don't exceed 5 digits, correct?
Yeah.
So does the R000 mean we must add 3 zeros to any numbers that we see in this table?
Yes.
Okay, so just to help us, if we take that first column, audit, and it's headed February 2015, do you see that?
Yeah.
There's a number in brackets there, 47. Do you see that?
Yeah.
That's not 47 rand, is it?
No, that's 47.
What is it?
47,000.
Okay, so every number in this table we must add 3 digits to. in a sense multiplied by 1,000. Is that right?
That's right.
Okay. Right. Then I'd like to know, under the heading senior debt, do you see that halfway down on the left-hand side?
Yes.
What is that describing?
That is a working capital facility that was approved, the 6 million.
Okay, so just to remind ourselves, there was an approval on the 6th of February 2017 for a working capital loan of 6 million rand at 4% interest, correct?
That's correct.
Okay, and then just help me if we move across from that senior debt and follow it through the columns. If you go to July 2017's column, Chair, that's about 5 along from the left.
Yes.
And you follow it down to where it is in line with senior debt. There's a 6,000 rand there. Do you see that? Well, there's a 6,000. We have to multiply it by 1,000.
Okay.
So
Yeah.
it signifies 6 million, correct?
That's the one.
Is that showing us the 6 million that would have been made available through the loan facility to EML?
That's correct.
And why is it shown as coming into the cash flow position of the business in July 2017?
So that is a peak period. It's a period when the full facilities would have been dispersed.
Right.
So it's coming earlier, but it reaches 6 million in 2017.
In July of 2017?
Yes.
Right. Because the approval was in February. So as I understand this, it's anticipating that by what you call the peak, the full facilities will have been made available, and that's why we have 6 million there, correct?
That's correct.
Then help me, the next line under that, still under senior debt, says proposed IDC loan repayments, correct?
That's correct.
And then if we follow that across, that line starts in February 2019 with an amount of 2.640 million. Is that right?
That's right.
What is that?
So those are the repayments.
Of the loan of 6 million
Of the loan of
that was extended in by July 2017,
Yes.
correct? And if we track that along, please correct me if I'm understanding it incorrectly, but there's a repayment of about 2.6 million in February 2019, correct?
That's correct.
There's a next repayment in February 2020 of 1.4 million or thereabout.
That's correct.
And then there's a repayment in February 2021 of about 1.9 million, correct?
That's correct.
So that, insofar as capital of the loan is concerned, is repaid by February 2021, correct?
That's correct.
If we could then go to the next line, what is that?
So that is the interest. So the first line was just showing the capital. Now this is the 4% interest.
Right. So those start to be repaid, from what I can understand here, in July 2017. Is that right?
That's correct.
And then you track those numbers through, and if I'm understanding this correctly, by February 2022, that's when the last interest payment of 38,000 is made. Is that right?
That's right.
Okay. So, just so that we're on the same page, the working capital facility of 6 million, according to this cash flow statement, was going to have been fully repaid, capital and interest, by February 2022. Is that right?
I'm sorry, Ms. Hofmeyer.
Sorry, Chair.
February 2022.
Yes.
Oh, that 38.
That 38. That's the
yeah.
final payment, as I
Okay.
understand Mr. Mainganya's evidence, on this facility, and it would be towards interest. So am I right, Mr. Mainganya, that the repayment takes place and is concluded by February 2022?
That's correct.
Thank you. Let's move to the second facility that was available. That is under the heading mezzanine debt. Is that right?
That's right.
So what does that signify, the mezzanine debt? Which loan was that?
That was a 6.5 million facility for equipment.
And the interest rate on that was?
This is the 13.8% real after-tax return.
Thank you. And again, I understand this cash flow statement to work in the same way in this line as we did with senior debt, but please just check me if I'm incorrect. If we take July 2017 again, because that's always the peak when the full funds will have been extended, you see an amount of 6.5 million there. Do you see that?
Yeah.
What does that signify?
Again, it signifies that it's fully dispersed at that time.
So by July 2017, EML has received 6.5 million for the plant and equipment loan, correct? And then if we go down a line again, what this is reflecting on my understanding is the repayments of that loan, correct?
Yeah.
Okay. So they start in February 2019, is that right, with an amount of 2.1 million?
That's correct.
There's a second payment in February 2020 of 2.1 million?
That's correct.
And there's a third payment in February 2021 of 2.1 million.
That's correct.
So insofar as the repayments on that loan are concerned, they are completed by February 2021, is that right?
The capital portion.
Yes, again, capital, right. And then there's something called, on the left-hand side, bullet payment. What does that mean?
So that is the interest on that facility because it's not priced like the first one.
Right.
So the first one incurs interest as time goes. That's why the repayments start when it's dispersed. This other one, it's priced like an equity instrument. So the return on it is achieved at the end. That's why it's referred to as a bullet facility at the end.
Oh, okay. So the liability to pay the interest only kicks in later, correct?
Yeah, so we start collecting the capital first,
Yes.
and then the return is collected later.
And as I understand this document, the first interest payment is in February 2021, is that correct?
That's correct.
And it's in the amount of 2.7 million?
That's correct.
And then the second interest payment is in February 2022, the same amount, 2.7 million, correct?
That's correct.
And so again, similar to the working capital loan, the plant and equipment loan is similarly repaid by the end of February 2022, correct?
That's correct.
And that, February 22, is 5 years from the decision in February 2017, correct?
That's correct.
Thank you. Right. You, in your evidence, wanted to talk about an error, and I stopped you, and I apologize. Let's understand the error that was brought to the attention of the IDC by the Commission's investigators. What is the error on this cash flow statement that we're looking at?
So we recall that the client said it had got equipment donated to it by Dinel of 14 million, and we valued it at 7 million ourselves. So that donation is reflected as income in the hands of the client, but it's asset, it's not cash. So when we do the cash flow statements, we must take it out because the client didn't receive cash, it just received assets. So in this cash flow statement, the income should have been reduced by the value of that donation to take it out. And that is the error that happened. It was not adjusted out.
And what amount was the error?
So the adjustment is about, to add back that income, I think it would be around 6.903.
Yes, so about 6.9 million, right.
Yes, yes.
Now, Ms. Mainganya, how could an error like this occur in your rigorous processes that you've described?
Chair, I think an error like this shouldn't happen.
Could you, Ms. Mainganya, if you wouldn't mind, just a bit closer, thank you.
I think I've given up. Your voice seems to be just low by nature.
Sorry, Chairperson.
I
We'll
don't
try
know
and
if the
remind you to
technicians
bring it
have-
closer.
whether there's anything the technicians can do.
Okay.
Yeah.
Yes, Chairperson, I was saying it's regrettable that this error was not picked up by all the processes, including the peer review processes.
Because, Ms. Mainganya, if I may just come in there, I mean, your description of it with respect, is a very simple description. It's not a complex matter that it should not have reflected a 6.9 million rand cash position insofar as the Denel asset donation was concerned, is it? It's not complex, the error.
It seems something that could and should have been easily picked up.
Yes, Chairperson. The amount should have been added back. I don't know how it was missed. It should have been added back because it was not a cash receipt, it was an asset receipt.
I think we probably want to ask the same question. What are the chances that it was a genuine error? What are the chances that it wasn't a genuine error in your own assessment?
Yes, Chairperson.
Or is there something you are unable to?
No. I have engaged with the team that prepared the financial model, and I also showed them this error. They indicated to me this was a genuine error in the assessment. I didn't get the impression that it was done intentionally when I interviewed them. I interviewed both the financial specialist and the head of the department, and hence I requested them to do another calculation to say, had this error not been done, what would have been the impact on the cash flows?
Okay.
Thank you.
It wasn't your question.
No, mine was close to it, Chair, so mine has not become necessary any further. Mr. Mainganya, when was the error first made known to you?
I think it was around May when I had interview with you.
With the Commission?
Yes.
Thank you. And what steps did you take? You've indicated to the Chair you did go back to engage with the financial team. I also understand from your affidavit you asked them to look at the numbers again, in a sense. And that is the second spreadsheet that you have in front of you, Chair. And it's at paginated page 21. That's in DD 13A. Mr. Mainganya, why did you ask for this recalculation of the cash flow statement to be done?
Chairperson, when the Commission appointed this to me, they wanted to know whether the business would have been viable should this error not have been done. Hence, I requested this to be redone.
And Mr. Mainganya, I understand your affidavit to say it would still have been viable. Is that correct?
Yes, I'm saying the facilities, the working capital, the first one, would still be repaid within 21, but the mezzanine one facility would be repayable a year later than was anticipated.
It's that last part that I want to explore a bit further with you, Mr. Mainganya, when you say the mezzanine debt, which for our purposes, I want to suggest we call the plant and equipment loan, because that's how it was referred to in the decision making. I understand you to say the plant and equipment loan would have been paid later, repaid later, but only 1 year later than on the original calculation. Is that right?
Yes.
Yes. However, Mr. Mainganya, if you go back to page 576, remember we had determined on that page that the plant and equipment loan would have been paid back by February 2022. Do you see that?
Yes.
If we look at that same line on page 21, which is the reconstructed cash flow statement, you'll see that the plant and equipment loan is only repaid in February 2025, correct?
Yes.
So that is more than a year later, correct?
Yes.
It's in fact 3 years later.
Yes. Oh, so Chairperson, remember the terms of the of the equipment facility, at that you only deduct payments such that there's cash available of $1 million. So when you repay, the client must remain with $1 million. So if every year when we test the model, we find that should we ask for repayment, the client would have $1 million less, there's no repayment due in that date. So because of this error, which had shown that the client was having more cash than it had, the team modeled repayments earlier than the terms of the facilities. The terms of the facilities say that the repayments must start in 2021, but because it was showing an erroneous cash, they were starting earlier than the terms of the facilities. So as per agreement, as per agreed on the credit approval, the repayments must start from 2021 to 2024. But they started earlier because of this cash. So when we correct this adjustment, we start sweeping with the terms of the facilities from 2021. So the terms of the facilities said the client must have repaid by 2024 as per agreement. But on the restated model, it repays by 2025. That's what I mean when I'm saying it repays a year later than the first model.
Thank you, Ms. Mainganya. You'll recall when we were looking at the decision taken on the 6th of February 2017, I said we may need to come back to it when we looked at the cash flow statement. And your clarification now has been helpful in that regard. But I would like us just to go back there if we may, so that I can be sure I'm entirely understanding your position. You'll find that in DD 13B, and it's at page 265. You'll see under 2 there, that deals with plant and equipment loan, the one we're interested in at the moment, correct?
Yes.
Now, it's just, the wording here does trouble me, because it seems on its face to be contradictory, but you may assist me there. It reads, a 6.5 million rand plant and equipment subordinated loan facility to be used for the upgrade of plant and equipment and the purchase of Bowsers. The facility will have a term of 5 years and is expected to achieve a 13.8 real after-tax return. Repayment will be in the form of cash sweeps from financial year 2021 to financial year 2024, maintaining a minimum cash balance of 1 million, with cash sweeps occurring every 6 months, beginning 28 February 2018.
Yes.
I don't understand that. Can you assist me there?
I looked at that, Chairperson. So,
if you could just come a bit closer.
So it was contradictory to me. Hence, I looked at the actual agreement. The actual agreement does actually correct that. So it's not 2018, it's 2021 in terms of repayment on the actual subordinated agreement with the client.
So was this an error that was then picked up before the agreements were concluded, in your view?
Yes.
So the approval that was given didn't make sense at point 2, did it?
Yes, the facility was only supposed to start from 2021.
And then help me with one last part. Why would you refer to it as a loan facility of 5 years when it ends up being a loan facility of 8 years?
I think it refers to the repayment period, the 5 years.
So there's basically a holiday of 3 years, is that right?
Yes, because this is an equity instrument.
So they get to fund their plant and equipment from July of 2017, but they only have to start repaying that in 2021,
Yes,
is that correct?
That's correct.
Thank you. But you agree with me that it can't possibly have been that they started cash sweeping in February
No, that's correct.
2018.
That's correct.
Let's go back, if we may, just to that page
I'm
21.
sorry, just so that I follow
Yes.
that part. Is that regular for them to have that holiday?
Yes, Chairperson. We model what the client can afford. Sometimes, because the cash flows are smaller in the beginning, we give clients a moratorium.
Yes,
so-
but you recoup
Yes, we
later
recoup- we
whatever
recoup.
they would have
Yes,
paid
yes.
earlier.
Hence, you can see the return on this facility is much
Okay.
higher to compensate for that period
Okay.
that we give them a holiday for.
Okay, thank you.
And then if we go back to 21, but maybe before we do that, just to pick up on the chair's question. Of course, all the time, correct me if I'm wrong, the IDC is deciding which applications to fund, correct? Is
That's
that right?
correct, that's correct.
Thank you. Just for the record, you need
Yes,
to
that's
give the
correct.
positive answer, not
Okay.
the head nod.
Okay.
So it's assessing at any point in time which to fund and whether it has 3 years receiving no repayment in relation to a particular applicant as compared with others, I assume would be something it takes into account. Is that right?
Yes, that's correct. Because the subordinated facilities are treated as an equity instrument. So the return on them is much higher.
But delayed.
Delayed, hence the period is longer.
Indeed.
And- yes.
So it's, I would suggest to you, a balance that has to be struck when financial viability is assessed.
Yes.
You get a bigger return at the end, but you don't get repayment in the interim, and I assume you'd have to take into account that impact on the rest of the IDC's decision-making, albeit that we're dealing with fairly small figures here. I accept that.
Oh, yes. So we assign capital in terms of how much we can provide under these facilities and whether the other facilities do compensate for them. Because we have many facilities, others are repaying during the period of moratorium that we grant to other facilities.
Thank you.
Where you give a client a holiday, as we call it now, the compensation that you structure into the whole arrangement, whole deal, you just mentioned that later on the repayments are higher. Would the aim be to achieve the same benefit for IDC as IDC would have achieved if there had been no holiday? Or is the position that because you have been given a holiday, IDC will structure the repayments in such a way that it must end up getting more from you as a client than otherwise would have been the case if there had been no holiday? In other words, is the aim to simply achieve the same thing because you just want to assist the client? Or is there an element of saying, well, we must punish you a little bit in order to discourage people from wanting to get into holidays?
Oh, okay, Chairperson, thanks. So I wouldn't say...
Or is that something that you are not sure about?
No, I'm sure
Yeah.
I can explain it to you. So it's not a
You wouldn't use
punishment.
punish.
It's not a punishment to the
Yeah.
client, but it's an assistance to the client because the type of clients that we fund, some of them are struggling.
Yes.
So in the earlier periods, they are not able to pay. But over time, they get more contracts, the business survives. So we give them these facilities as if the IDC is investing in the business. But because we are suspending our cash flows, the clients must compensate us for that in the end. So, and also, these facilities are subordinated, meaning other creditors are paid first than the IDC. So there's more risks to the IDC. Hence, we say the client at the end, when the business is viable and making money, they must compensate us for that risk that we're taking so that we can plow it back and fund other clients with the return that we get. But as in this case, we model it such that we are only able to get that money if the client's business succeeds as well. So should the client fail, other creditors will be paid first than the IDC. That is the assistance we are giving to the client. I don't see it as a problem.
Yes, no, I understand that. I think what I'm looking for is whether you say, if we hadn't given this client a holiday over, for example, a 5-year period, we haven't given this client a holiday of 2 years? For example, the first 2 years, and they start paying on the 3rd year. Whether you look at simply putting yourselves in the same position you would have been in financially, in terms of what you get.
Yes.
Or whether you actually make more, you seek to make more money by reason of the fact that there has been some holiday.
We try to achieve both.
Or you try to achieve both?
We try to be compensated for the longer period.
Yes.
And we try to be compensated for the riskiness of the facility.
Okay, thank you.
Thank you, Chair. Mr. Mainganya, just in relation to page 21, you were explaining...
Are you back in his...
We are back in his affidavit,
Yeah.
which is DD 13A. This was the recalculation done when you went back to the finance team, is that right?
Yes.
And it...
You did mention the page, but...
21, Chair, but it's also on the big A3 that I handed up, which might just be more convenient to look at.
Okay.
This was the reconstructed cash flow statement done by the finance team when the error was drawn to their attention. Is that right?
That's right.
It does not, as I understand it, account for the increase in the interest rate that ought to have been paid by EML if it, as we've agreed, did not qualify for MSEP funding. Is that right?
That's right.
That would have increased its interest payments from 4% to 13%, correct?
as we'll see later, the client was able to attain other contracts. So although for this loan, the primary source of repayment was a SAA contract, the IDC was seeing it as helping it to be sustainable, to be able to bid for other contract. Hence, we were investing in the client, getting sufficient equipment to not only get the SAA contract, but to be able to bid for other contract. And for the point you are raising, there is a risk in that the client may not get those. And again, to the point you are raising, it is why those other facilities are marked at a higher rate, because the IDC carries more risk. But we do set up clients like that with an initial contract, and we push them to find other revenues so that the business doesn't end on completion of that contract. So that's why we were prepared to take the risk to put the client, since we've invested a lot in the equipment that the client was having, which had a lifespan extending more than 5 years.
And what if they can't get other contracts?
So that is a risk we are in as a development finance institution. Sometimes clients are not able to get other contracts. Sometimes the business is closed. Sometimes they get other contracts. Sometimes it does happen that we suffer losses and they cannot repay our facilities.
I can understand the idea on the part of an institution such as IDC of saying we are prepared to take some risk in order to assist maybe a certain sector of business or society and so on. But I wonder what measures the IDC would take to try and make sure that its decision to take that risk is a reasonable one. Particularly where you're looking at people who might be depending on tenders, where they tell you we have hope that we'll get 2 or 3 other tenders, and they might not even know who else will be tendering for those tenders. What are their prospects? What will be their prospects of getting those when they don't even know who else will be bidding for them? It seems different to me from somebody who says, look, this is the business I have now, and here is another business that I'm going to start. Here's my business plan. You can look at it, and they can motivate. You can assess the risks in a certain way. There are not too many variables. But I'm just thinking, if it's an entity that is talking about getting other tenders in Johannesburg, in Pretoria, in Bloemfontein, I'm just making examples, you say, but we have no idea whatsoever what your chances will be. Are you able to shed any light as to how those risks are assessed?
Yes, Chairperson, and thanks for that question. It is a difficult space that we find ourselves in, because on the other hand, we have to play that role of assisting new entrants in the industry. We try our best to estimate on a balance of probabilities that the client has a reasonable prospect of getting that tender. But we must always remember that our funding only flows on him getting the tender. So we won't give him money until he gets it. But then we also try to do a pre-assessment of the ability of the client. If somebody who's never been involved in this business come to IDC and say, I've bid for this, fund me, and we would ask questions, do you understand the industry? Are you in this industry? So in this particular client, what the submission says, it says that this particular client had been in existence for 10 years. And as we know, most of the clients we fund, the small businesses, fail within their first year. So this one, at least as per application, had been there for 10 years. It is in this industry. But the client is coming to us and saying, I've been doing this on a piecemeal. I don't have the right equipment to be able to bid for bigger businesses. And for me to bid for SAA, it requires me to have this licensing regime. It requires me to have this equipment. But then on that basis, we assess, we say, at least this client has survived for 10 years in this business. We can take some risk on him that he will be there even post the SAA tender because of his previous record. So
Looking at the track record.
looking at the track record. So, and it's not always the case, Chairperson. In other difficult sectors, we have to still try to facilitate, especially the entrance of new black people. Sometimes they just have the technical know-how, and then they don't have the equipment. So we also give them business support. So as you'll see later on in this client, we said he must go for corporate governance training. We gave him support in terms of appointing a financial manager. We assisted them with the financial support. So in addition to the funding, we try to give them non-funding support so that they survive post that client. But it is a risk that things don't always happen as we planned.
Thank you.
Chair, I note that we are at the lunch break time. If it's convenient, we can take the adjournment.
Okay, I think let's take the adjournment and we will resume at 2. We adjourn.
All rise.